Hi, this is Dr. Coleman, and I'll be talking to you on this video clip about IDEA, or the Individuals with Disability Education Act, that was passed in 1990. Those of you who have special education background experiences or have worked as special education teachers are very familiar with this. But just a couple of terms I'd like to read the definitions to you, because it's very important as school executives. The first one is FAPE, or Free Appropriate Public Education, and that means that all special education students should receive not only the regular instruction but also any related services as a special ed student. The other term is the Individualized Education Plan, or IEP, and those have to be developed for each student in your school, and there's some very specific requirements as well as forms and processes that have to be followed. One of the most important issues that come up, however, is discipline with special ed or IDEA students. And there was a clause that was passed called the Stay Put provision that requires administrators to leave a student in their placement while disciplinary action is occurring. But more importantly, if the handicapping condition is a manifestation in this behavior related to that, you really can't suspend these students for more than 10 days. And that became very problematic, particularly with disruptive students, for example, who might be BEH students or students with behavioral issues. There was a court case, and I'll refer to my notes here, Honig versus Doe in 1988, that actually required school executives to keep students in their placement regardless of this behavior. Well, with a lot of the violence that's occurring in schools now, as well as the problems associated with that, that was challenged. And then in 1995, in the Light versus Parkway School District, the court decided that if there was a continuing and clear and present danger to the student or other students or teachers or anyone else in the school executive had to document and prove that it was possible to remove the special ed student from the school setting. However, I highly recommend as a school executive, even if you're removing that student, that you make provisions to offer those services to that student, even if they're being removed from your school. For example, homebound services, the advent of online courses, sending teachers to the home. That really pays off for not only the school but the school district, because if you're ever challenged on this, particularly by those parents with an advocate, that you're not providing those services, these lawsuits are usually about $300,000 to $400,000. So it's very much worth putting those homebound services, removing the dangerous student, following the letter of the law, but making sure that you're still providing that student with a free and appropriate education.